We are live.
All right, we are back in Senate Judiciary. It's April 15th. We have Ben from Ledge Council here to talk about a few of the changes we've made to H44, and we'll also just have a general discussion as to any other changes we might make to this bill, and we'll proceed from there. Ben, the floor is yours.
Great. Thank you, Mr. Chair. For the record, Ben Opegrosky from the Office of Legislative Counsel. Just going through markup of H44 and act relating to miscellaneous amendments to the laws governing impaired driving. Picking up from last time we discussed the bill, there were a handful of suggested changes. The first one comes in section 1 in subdivision A8 of title 4 VSA section 33. You'll see here in the subdivision 8, the only change currently is striking the word juvenile. However, the general counsel from the Department of Motor Vehicles raised an issue that the current language as written in the statute as it is now may violate federal what's known as masking requirements. And what that is that the state must not mask, defer imposition of judgment, or allow an individual to enter into a diversion program that would prevent a commercial driver's license holder from appearing on the CLDS driver record database. And so she submitted some proposed language that would fix that, which I can, circulate to the committee. But essentially what it would do is that in this portion, it would essentially strike most of it and just accept those who are holders of commercial driver's license or permits from being subject to these provisions, because really the nature of family court being, having certain confidentiality provisions and then adjudications also being confidential, had, I think, the unintended impact of running in contravention to the federal prohibition on masking. So the language that she proposed would essentially cure that issue in this portion here. And I can, like I said, I'll happily circulate that language. Any questions on at least the goal of what the change would be? I know I don't have the language in front of you now.
Don't see any.
Okay, so moving on, the next portion would be farther down in 1202, subsection J. So this subsection J is a new addition, and this is the concern that was raised about sort of physical hindrance versus consent to submit to the collection of an evidentiary blood sample. So there was discussion really, in my view, surrounding this highlighted language here: shall not refuse to submit. And if memory serves, the committee's discussion last time, I think, centered on this creating sort of the mandate to comply with the evidentiary request for a blood sample pursuant to a warrant. And then farther on down in the statute 1202, to maybe changing the language to hindrance, or shall not hinder or obstruct the collection. So that would be the criminal refusal portion, and this would essentially, subsection J would set the expectation, if you will, that you either submit or comply. So I believe that was the source of discussion for the committee. So
I think, Ben, what the recommendation was, or what I remember hearing, is under where it says shall not refuse to submit, simply eliminate not refuse to, or just leave shall submit to.
Yes, that's one possible way if the committee has any other concerns, or so it would essentially read as that. So it's an affirmative obligation to submit to the collection of the evidentiary blood sample. It wouldn't have language surrounding consent to the evidentiary blood sample, because again, a warrant is really an obligation that's placed on the law enforcement officer after it's been issued by court. So this would essentially, the way that I would phrase it, creates the expectation to submit to the warrant.
So Senator Hashim, you have thoughts on that, or?
Yeah, I'm just trying to make sure that we're fixing the problem that was raised in the first place, or, that we're not also just not making it worse, in that if somebody is refusing to provide a sample of their blood, they're currently being charged with felonies, rather than criminal refusal. So, yeah, and I'm just trying to draw it from my memory, but Ben, are we still getting to the underlying point that this was trying to fix in the first place?
Right, so the way that it's structured now is that this creates the mandate, and then if we scroll down to the criminal refusal portion, excuse me. And you'll see here under subdivisions or subdivision 6, the addition of C here creates the criminal refusal penalty or basis for refusing to essentially submit to the blood sample. So yes, the overall objective that these achieve is that this keeps it within the DUI umbrella, if you will, and doesn't bring in a felony charge that carries greater penalties and doesn't have the same rehabilitative requirements that a DUI related charge does. The real issue for you all to decide was that specific language of, do you want to create the expectation in the previous portion that we just viewed in subsection J, and then somehow either keep it consistent in the criminal refusal portion that you see here, or perhaps create sort of an additional element of, affirmative conduct on the individual to either hinder or physically resist the collection as the basis for the criminal refusal. Does that make sense? Or did I?
Yeah, no, it makes sense. And I think that, and this is going back to the fact that for blood draws, there is no implied consent, right?
Correct. The way that this would go into effect is if the officer had gone through the warrant process already. That's how you have to acquire a blood sample.
So does hinders, after the warrant has been obtained? Okay, and if the word hindered is used in there, is that a misdemeanor or felony criminal charge?
Well, so if you were to put it in subdivision C here,
yeah,
well, it would still be a misdemeanor for a first time offender. Okay. Yep.
So if we just remove the word refuses and insert hinders, I guess.
So it could be hinders, it could be inhibit, it could be obstructs. These are sort of words of art, so to speak, but like, for instance, one of the felonies that someone could be charged with if they are in a situation where they are not, allowing the officer to comply with the warrant is resisting arrest or obstruction of justice. So there's a little bit, if you want to kind of take a nod from those statutes and use the word, it wouldn't carry the penalty, obviously, because it would still be within the DUI umbrella. But that could be a way to accomplish the goal of kind of creating that affirmative conduct, if that's the committee's goal.
What do you think? Senator Hashim, is hinders too vague, or is it good with that?
And the alternative was impairs.
It could be hinder, it could be inhibit, it could be obstruct. You could say physically resist, physically obstruct. I think there is a difference. I know what the committee was talking about is whether or not someone just sort of may not essentially assist the officer, but just sort of apathetically is there, arms spread, sort of like do what you need to do, as opposed to physically, maybe coiling their arms up and physically resisting. And in that situation, I think hinder, is this something that could be litigated? I mean, DUI cases are litigated all the time. So it's possible that if someone is charged for a criminal refusal because they hindered the collection of the evidentiary blood sample, that could become a factual issue that has to be litigated in court. But I kind of present these options that there are these are terms of art: hinder, obstruct, resist, that you could use. that have nuances associated with them, but it's really the committee's prerogative to decide.
Yeah, I mean, I'm thinking about the word hinders, and I mean, just thinking, since it is kind of general, if somebody is just saying, I don't want to do anything, and they just, don't participate in the process, like they just go limp and they let the doctors and the cops do whatever, compared to somebody who starts fighting and, recoiling and all this stuff. So I mean, I think leaving and narrowing it down to potentially physically disrupts or physically obstructs the process. I think that could be a more specific alternative that wouldn't necessarily sweep in the person who is just being apathetic to the whole process. Does the committee have any thoughts on that?
And if I may, Senator Sheep, as far as like, what is obstruction of justice in Vermont, and just so the committee knows, and since this is a law that's been on the books, there might be some case law that can inform if you use similar language here. So for instance, it's defined as corruptly by threats, force, or threatened communication, impeding or endeavoring to obstruct or impede the due administration of justice, or intimidating or impeding witnesses, jurors, or court officers. This includes causing bodily injury or damaging the property of such individuals. So that's a term of art that if you use obstruct, potentially, if that were ever to be litigated, there is some case law buttressing obstructive justice that might illuminate that term in court, if you will.
So could we clarify then that if it's obstructs, I see that we can use the word obstructs to get to the same point, then if we were to do that, would it be necessary to cross-reference the definition you just described, but still spell out that it would be a crime of criminal refusal and it would be the misdemeanor that they're getting charged with?
It's possible, and I should clarify that, that's in the law itself. It's not like, obstruction of justice means XYZ. So, I think I'd be doing a disservice if I didn't pull some case law for you to at least illuminate how the law has been employed, which I can do unless you're comfortable now doing that. But to answer your question directly, yes, you could say, obstruction of justice as defined in 13 VSA. I forget the statute off the top of my head. I'm sorry. But then, say that a violation of subdivision, 6C is a misdemeanor. You can make that distinction. It's possible to do it from a drafting perspective, at least.
Yeah. Okay. I mean, I think if there's case law that establishes it clearly, then I don't know that a cross-reference is entirely necessary. But
yeah, I would just want to look at that a little bit more in depth before I advise one way or the other. So just to put that out there.
Yeah. Now that works for me. If we move to obstructs instead of hinders, and just clarifying, well, before we make it official, clarifying what the case law says and whether or not cross-reference is necessary or unnecessary. And we have it spelled out that further down that they would be charged with criminal refusal rather than obstruction of justice.
Yes, that's how the statute's currently structured. So,
yeah. Right.
Yeah.
So
Okay.
what about any case law on the term impede? Is that?
I can pull all of it, so I can look in at, resisting as an arrest statute. So if you wanted to say resist the collection, I could see what the case law that came from that, obstruction of justice. I could look into inhibit as well. And that way, for the next time the bill's taken up, I can have language ready for you. And then some case law for you to kind of chew on about the different impacts of the terms.
Get caught up on one word or a word. No.
But does that sound like a reasonable course of action?
Yeah, that sounds like a good idea. I think, are there any other sections, or Ben, did you have anything else you wanted to touch on?
No, those were the three issues that I wanted to highlight, the masking issue with the federal, to be federally compliant, and then these two provisions when it comes to obstruction or hindrance and compliance with the blood draw.
Okay. Committee, anything further either in this section or any section in H 44?
I don't see any questions or hands.
Okay, great. So I think we'll just spend some time making sure we get the language right for this one, and then I imagine it's ready to go, and we can probably take care of it this week. All right.
And so, just one last question. When I do the amendment, do you prefer a strike all, or I could just do, for instance, like 3 instances of amendments? Does do you or the committee have a preference?
Which, remind me again, which process is generally more straightforward?
I mean, on one hand, a strike all would be striking the whole bill.
Right.
And so you have it all in the amendment again, as opposed to 3 instances of amendments, which would kind of just take the certain provisions pulled. So it wouldn't have the fuller context of the bill when it's introduced on the floor. So I don't know, from like a readability perspective, a strike all in one way might be a little bit easier to understand, but also would be a lengthier amendment.
Yeah, let's do the strike all then, just because so that everyone else on the floor knows what we're talking about. I find that that's a bit easier because now I'm picking up what you're saying. So yeah, we'll just do a strike all, please.
Okay. Sounds good.
Great. All right. Well, I think that completes the orders of the day. Committee, anything in general that we want to discuss?
Mum's the word
Look like
here.
you wanna say something. What was that?
I think mum's the word here. There's nothing.
Sounds good. Sounds good. I'm just looking at the list here real quick. All right. Yeah, so we can adjourn.